I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a Lawcast series talking about the newest SEC and other regulator statements on ICOs and related enforcement proceedings. On December 11, 2017, SEC Chairman Jay Clayton issued a statement on cryptocurrencies and initial coin offerings. Jay Clayton began his December 11 statement with an acknowledgement of the tales of fortune made and dreams to be made, which is a perfect description of ICO mania. Keeping with the SEC theme under Clayton, he then addresses ICO considerations for Main Street investors. In addition to warning of fraud and misrepresentation, ICOs and cryptocurrency trading is a national marketplace. Invested funds may quickly move overseas, and the SEC may not be able to gain jurisdiction or pursue bad actors or lost funds in other countries. The fact is that as of today, no cryptocurrency offerings have been registered with the SEC, though I believe and know that several are going through a confidential review process. Although Jay Clayton doesn't talk about what registration really means for an ICO, I note that since registration is the process of ferreting out disclosures, it will force an entity issuing an ICO to be clear about the usefulness of its token, if any, and the risk factors not only associated with its token in business, but the marketplace as a whole. My firm is currently working on registration statements as well as private offering documents for ICOs and blockchain technology entities. And the complexity of this new industry and technology and uncertainty associated with legalities, including not only securities matters, but the implication of swap and commodity transactions, tax ramifications, and intellectual property matters is confounding to even the best and the brightest. The importance of the involvement and efforts by market professionals is not lost on the SEC. In the beginning, many ICOs, believing that this new investment vehicle was somehow not a security and therefore outside the parameters of the securities laws in the SEC jurisdiction, forewent the advice of legal counsel and other professionals at all. Now that this belief has been rectified, in his statement, Jay Clayton reminds market professionals of their gatekeeping duties. Chair Clayton states, "I urge market professionals, including securities lawyers, accountants, and consultants, to read closely the investigative report we released earlier this year, which is the Section 21A report on the DAO, and review our subsequent enforcement actions." It's clearly a warning shot. He continues, "Following the issuance of the 21A report, certain market professionals have attempted to highlight utility characteristics of their proposed initial coin offerings in an effort to claim that their proposed tokens or coins are not securities. Many of these assertions appear to elevate form over substance. Merely calling a token a utility token or structuring it to provide some utility does not prevent the token from being a security. On this and other points where the application of expertise and judgment is expected, I believe that gatekeepers and others, including securities lawyers, accountants, and consultants, need to focus on their responsibilities. I urge you to be guided by the principal motivation for our registration, offering process, and disclosure requirements, investor protection, and in particular, the protection of our Main Street investors." And again, that's a quote directly from Jay Clayton. Attorneys and other professionals are not the only groups that the SEC is taxing with gatekeeper responsibilities. Jay Clayton adds, "I also caution market participants against promoting or touting the offer and sale of coins without first determining whether the securities laws apply to those actions. Selling securities generally requires a license, and experience shows that excessive touting in thinly traded and volatile markets can be an indicator of scalping, pump and dump, or other manipulations and frauds. Similarly, I also caution those who operate systems and platforms that affect or facilitate transactions in these products that they may be operating unregistered exchanges or broker-dealers that are in violation of the Securities Exchange Act of 1934. Again, a quote directly from Jay Clayton. Although Jay Clayton does not indicate so, I am unaware of any properly licensed secondary market or exchange for the trading of securities cryptocurrency cryptocurrencies at this time. T0 is properly licensed, but not up and functioning as of the date of this lawcast. Jay Clayton's statement is not all negative. He recognizes that ICOs can be an effective method to raise capital and fund projects. He also recognizes that not all cryptocurrencies are securities. A specific example would be an in-app game with token purchases that can only be used to reach another level within that game. However, Clayton points out that by and large, the structures of initial coin offerings that he has seen promoted involve the offer and sale of securities and directly implicate the securities registration requirements and other investor protections of the federal securities laws. The Division of Enforcement has been instructed to vigorously police the ICO marketplace. Finally, the SEC encourages investors to conduct thorough due diligence before making an ICO investment. In that regard, the Clayton Statement provides a list of basic questions that should be asked and considered before making any investment. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.